Welcome to the Legal Insight podcast by HHQ. It's the show where we help you unpack the world of law, business, tech, and more. Welcome to season 2, guys.
Good to be back.
Thanks for having us, Zach.
Oh my gosh, I can't believe we've recorded 14 episodes of this and now we're entering episode 15 of the Legal Insight podcast. So it's the new year. Happy New Year, guys.
New year, new me.
You too.
What's new? What's new with you guys this season?
I think everything is new. It's a new year in 2024. Looking back, we have achieved a lot. We achieved big clients, big deals.
Yep.
And then entering 2025, we are hoping that with new laws coming in, just like PDP amendment, online safety bill and whatnot, we are believing that there will be a lot of exciting development from a legal scheme, from a legal framework as well.
Yep. And of course, New Year, we are constantly on the lookout for new clients, new work, new file. And of course, we are looking for new talent as well. If any of you would like to join us at Technology Practice Group, drop us an email. You know where to look for us.
That's right. So you heard the man. We're expanding the Technology Practice Group.
Right.
So send in your resumes. Check us out on LinkedIn if you haven't already. So once again, welcome to season 2 of the Legal Insight podcast. Now, this season, we're aiming to bring you more regulatory updates, more guest speakers, more insights, and definitely more areas of law as well. So we're aiming to bring you the best value content that you can possibly have. 15, right? We're going to be discussing the Personal Data Protection Amendment Act 2024, fresh out the oven last year, and it will be enforced this year in phases, I heard. Now, due to the high demand and importance of this new amendment, we'll be splitting this discussion into 2 parts. So this is part 1. Be sure to wait for part 2 after this episode, right? Now, today I'm excited to welcome back Johnson, the head of Technology Practice Group, and Khai, the co-head of Technology Practice Group. Now, Johnson, to start off, the PDPA Amendment Act 2024 represents a significant progression in Malaysia's regulatory landscape. Now, from your perspective, would you agree that this is a good step forward, and do you think it is timely?
Thanks a lot, Zach, for the question. I think it's definitely a very important step for Malaysia, for our privacy law. But if you're asking me whether it's timely or not, I think not only me, I would say that most legal professionals in Malaysia would not call this timely. I think that what we are doing as a country, we are doing catching up.
Yeah.
Because for the longest time, some may not agree, but based on our conversation with many legal professionals, many in-house lawyers, many lawyers, the common perspective, the common opinions about the old PDP is that it's a paper tiger. So many companies, many in-house, many organizations, they are not giving the right attention that the law deserves due to its perceived lack of impact. So a lot of companies, they are just treating it as a paper tiger. The law is there. I have PDP notice, I have PDP policy, but am I actually investing resources to take it seriously? The answer often is actually no. And then with this amendment, I think that Malaysia, what we are doing, we are actually updating our law, we are amending it so that we are catching up to the global standards, something like GDPR. So if you ask me, is it timely? I think it's not exactly timely, but everyone in Malaysia, we're excited for what is to come. At least we are able to catch up with a global standard like GDPR.
Yes. Now, Khai, do you agree with Johnson? Is the paper tiger finally gaining flesh and bones? What are your thoughts on how the PDPA Amendment Act reflects current global data protection trends, and how does it compare to more mature frameworks or frameworks which have already been there, like Johnson mentioned, the GDPR?
Yeah. Thanks, Zach. So certainly, I do absolutely agree that the amendment to the Personal Data Protection Act is giving the so-called paper tiger sharper fang, definitely. And comparatively to global standards such as GDPR, well, what all of us data protections practitioners hold as the gold standard when it comes to data protections, right? I think this amendment really brings us much closer to GDPR, if not substantially similar to the standards imposed under GDPR, right? And especially, I think the amendment also brought forth long-awaited clarity in certain areas of our Personal Data Protection Act, such as the transfer of personal data outside of Malaysian jurisdictions, right? Under what circumstances you are able to transfer. So I think the amendment is definitely something that is, I would say, long overdue. But I'm glad that finally we are here. The act is here. The amendment is here.
Now, Johnson, I understand the PDPA Amendment Act 2024 will take kind of a phased or stage rollout approach.
That's right.
Why the phase rollout approach, and why not just have a hard deadline and everything is rolled out, everyone gets on board?
Yes, Zach, you're spot on. Absolutely right. So what happened is instead of a full implementation of the PDP Amendment Act this year, our government, our parliament, they have decided to actually take this stage rollout approach. So they will be in phases. So the first stage will be on the 1st January, followed by 1st April, and last but not least will be 1st June. And then if you ask us, we actually do not have any idea why are they doing so. But our educated guess is just to ensure that all companies, all data controller, they can be fully prepared for what is to come. And I think it is also very important because, as we know, the market sentiment, most legal team or the in-house team, they are seeing this as a paper tiger. And then right now, with heavier penalty, with heavier imprisonment terms. So right now, companies, they would need to look at the law. They will need to ensure that the policy is well updated. All the new amendments is being well incorporated into the company, into the organization as well. So I think that with the raw approach, companies, they wouldn't have any excuse saying that, look, I don't have time to prepare. So if you ask me, I really think that this is a very good approach, which allows all companies, all organizations within Malaysia to get ready for what is to come with the new amendment.
Thanks. So when you say everyone to get ready, what do you mean by everyone? Like what companies, who is supposed to get ready for this?
So basically, if you actually look through the PDPA amendment is mainly to govern, I would call it mainly data processor, data user, but data user is an old term. Under the new law, they're calling it data controller, and last but not least will be data subject. Technically, every company which collects, which process or store data, they will be named as data controller. So let's say like a law firm, like a clinic, like a school, like a bank, all these things, all these organizations, they are collecting data, they are processing data. All these will be categorized, will be named as data controller. So technically, I would say that at least 95% of the companies in Malaysia, they will one way or another be categorized as data controller. And if you are data controller, you will be bound under PDP.
Right, thanks for that explanation. Now let's start with stage 1 or phase 1, right, Khai? Can you explain what will happen in this first stage and what companies would need to take note or prepare for it?
Well, I would say this first stage really, if I'm a company, if I'm a data controller, the amendment that are being implemented on this first stage really don't concern me, I would say, at all, right? It is more or less just administrative changes, change of certain references of the words in the Personal Data Protection Act, say change of Penafta to Pesuruhjaya. Those sort of things, adding of a few words in some of the sections in the PDPA. So I think first stage in and of itself, companies will not feel the impact, but rather I think it's more of a snooze alarm for them to know, for companies to know that, hey, okay, the new act is now in force. But the real impact, right, those parts that will really affect how I run my company, how I carry out my operations, will not be here so soon, but I better start prepare for 1st of April and 1st of June, like what Johnson has mentioned just now. So really, I think if you look into the amendments to be implemented specifically under this stage 1, I would say that it doesn't bring much of an impact to companies.
It's like a tutorial mode, like when you're playing a game. It's like
Yes, correct.
just going through.
I think it's a bit like a warm-up exercise telling you, look, we are entering the main game now. So it's time for the warm-up, time for you to look into the law now if you are not already doing so.
Yep. I, for one, don't believe in warm-ups, and I tore my tendon last year. So it's good to warm up, right?
Exactly.
Now, one of the key changes in the second stage or the second phase is the inclusion of biometric data as this thing called sensitive personal data. Now, what are the practical implications for organizations collecting biometric data? And, I'm thinking of sectors like healthcare. Yeah.
So that biometric data, I would say that it's a new term being introduced under the PDP Amendment 2024. So for the longest time, whenever clients come to us, they're asking us, actually, how do you categorize biometric data? Is it considered personal data? And also, most importantly, is it even categorized as sensitive personal data? And then this is always slightly confusing because the old law, they don't really categorize, they don't really define biometric data. But as we know, with the new age, with the digital age, most of the industry, especially the healthcare industry, they are actively collecting, actively storing, and most importantly, they are actively processing biometrics data. So with this new amendment, the law makes it super clear. Biometrics data is not only personal data, it's well defined, well categorized as sensitive personal data. So with that, there will no longer be any confusion whether your biometrics data that you pass to the hospital, can they process it? How are they supposed to process it? Can they even abuse it? So right now the law is very clear. Biometrics data is sensitive personal data. And for any data controller, in order for them to process it, they have to process it, treat it like a sensitive personal data with utmost respect. They are not able to just process or abuse your personal data as they like in the past.
Thanks, Johnson. Now, regarding the expanded legal obligation of data processors, just now you mentioned there's data processors, there's
Data
controllers.
data controllers.
Yep.
So for data processors, you mentioned that there's expanded legal obligations. Now, could you explain more about this and what should data processors actually take note of with the amendment?
Yep. Essentially, I think if we looked at the previous or rather the old Personal Data Protection Act, there is this principle called the security principle, right? Essentially, data controller or then data user, right now data user still, they are supposed to put in place certain security measures, adequate security measures to make sure that the personal data that they have collated from the data subjects and their processing of these personal data are secure, right? The storage, the processing, and everything transfer, they're all done securely in a secure manner to prevent loss, misuse, unauthorized access, those sort of things. And the act primarily imposes the obligations to ensure security on the part of data user / controller. And it even goes to the extent where it says that if data user or controller is appointing a data processor to process the personal data on their behalf, they are supposed to ensure that the data processor would put in place same amount of safeguard as well, right, to ensure security. But now the new amendment, it has come in to say that, look, without even needing the data user or the data controller to say that contractually to ensure or technically to ensure data processor have adequate security measures, the act itself would first and foremost already impose that primary obligations on the part of data processor. Essentially, they are saying that data processor, you have the same amount of obligations under law as data user and data controller to put in place security safeguard and security measures when you are processing personal data, not for your own purpose, but for the purpose and on behalf of data user and controller. Yeah. So now, if I can put it simply, data processors are essentially directly being implicated, or rather directly being imposed that obligations under the law to ensure security of their processing.
Right, that's very clear. Now, Johnson, there's been a removal of the whitelist regime for cross-border data transfers, which actually introduces, I understand, more flexibility.
Yes, Zach, you are right. So previously, before the law, before PDP has been amended, there's always a huge challenge, a huge confusion where the personal data could be transferred from Malaysia to another jurisdictions. And then right now, I think that with the new amendment, the law, they make it very, very clear, very easy, and also position Malaysia as a more data-friendly country. So in order for data controller to transfer personal data from Malaysia to another jurisdictions, all they need to do is just to ensure that it satisfies one of these two requirements. Number one is to ensure that the country that will be receiving personal data, they do impose their own personal data law that is somewhat similar to our legal standards. Yeah. So that is number one. Number two, if that is not the case, they just have to ensure that the receiving country, the country that will be receiving personal data, they do have certain kind of legal protection in processing personal data that is similar to our standards. So right now, in order for any data controller to transfer personal data from Malaysia, let's say, to Singapore, it will be way easier as long as they fulfill one of these two requirements.
Thanks, Johnson. Now, Khai, earlier you mentioned the paper tiger has now grown sharper fangs.
Yes.
And, without penalties, without enforcement, it's a tiger without a fang.
Yeah.
Now, there's an increase in penalties for non-compliance under this amendment, I understand. Now, could you kind of elaborate more on this? And do you believe that this will lead to a cultural shift in how organizations here actually approach data protection?
Yes, Zach, certainly. I think, as you have rightly put, the paper tiger certainly have a sharper fangs right now. Essentially, when companies have a breach of the law, the Personal Data Protection Act, the penalties under the Act has now been increased to up to 1 million ringgit at the maximum, or 3 years of imprisonment term for personal imprisonment terms, right, for management personnel for severe breaches. So this, whether or not this will bring forth a cultural shift or not, I would think that the answer is yes. Primarily because ever since this the Personal Data Protection Amendment Act has been announced or disclosed to the public, Johnson and myself, we have received several inquiries on some of the new obligations being imposed under the Personal Data Protection Amendment Act. For example, the requirements for a data protection officer. So I think a lot of people are taking a more proactive stance, a proactive approach rather than reactive. They now, instead of waiting for someone to tell them that, hey, I think you need all these things, they themselves are finding out on their own initiatives what is required in order for them to comply with the amendment. So, but of course, I think now that the tiger has a sharper fang, to whether it bites or not, I think that's still a question mark. Even if the tiger has sharp fangs but it doesn't bite, I think ultimately it's still a tiger that doesn't bite, right?
Yeah, that's right.
So we still have to wait and see to what extent the tiger will bite.
Yeah, just to add on in relation to the cultural shift, I think on top of what mentioned by Khai, one of the key questions that we received is considered about DPO, because DPO is one of the key requirements being introduced. Another thing is actually last year alone, we actually received quite a number of inquiries in relation to data breach. So back in the past, whenever there's a data breach, I think that most companies are just taking it very lightly. And then due to the new amendment, in which we are going to discuss a bit deeper in the next episodes, there is a mandatory data breach requirement. So in the event there's a data breach, you need to notify. And then if you do notify, you'll face very severe penalty. So with that, companies, the legal team, the moment they face any data breach, they're calling us, they're asking us, what are we supposed to do? How can we advise them? How can we assist them? So I would say that it has already happened, and that is happening a lot more frequently now.
Right, that's all the time we have for today. What is a DPO? What are we supposed to do? What are the obligations? Well, you have to find out in the next episode, in part 2 of this crucial discussion on the PDPA Amendment Act 2024. Now, thank you, Johnson and Khai, for your time today.
Thank you.
And stay tuned for part 2. Thank you for listening to the Legal Insight podcast. It's the show where we help you unpack the world of law, business, tech, and more. Stay tuned.